I want to talk with you today about something called preliminary hearings in felony matters. Now, under Mississippi law, a person who is charged with a felony is entitled to a preliminary hearing so long as there's not been an indictment in their case and they demand it. Those are the only two requirements. You have to make a demand and you have to have not been indicted. Now, if a person makes that demand, they must have their preliminary hearing within 14 days. Otherwise, they are to be released on their own recognizance, except for certain special circumstances that generally don't apply to anybody who would be watching this video. Now, what happens at a preliminary hearing? Well, a judge is to make a decision as to whether or not there is probable cause to believe that the person who has been charged with a crime actually committed this particular crime. And then they generally address the issue of bail or release. So at the preliminary hearing, the state, the prosecution, they will put on a witness who will testify about the investigation and what led them to make an arrest of that defendant. Usually, and most times, I'd say roughly 9 times out of 10 or a little bit higher, the judge will find probable cause at the end of that hearing because it's a pretty low standard, at least compared to what we think of in criminal law, which is that famous beyond a reasonable doubt standard. That doesn't apply until the jury at trial makes a decision about guilt or not guilt. Okay, so this is an early preliminary matter that doesn't have that higher standard. All right.
Want to know more? Like and subscribe to our Eichelberger Law Firm channel to check out more videos on this and other important legal topics.